Thank you. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys -1 are present. Would you like to begin without Mr. Perkins?
Yes, Judge. He's in the building. That's fine.
Thank you. The record should reflect that we are outside the presence of the jury. This matter comes before the court on the defendant's motion to exclude the testimony of a child witness. The issue before the court is whether witness taint, meaning the implantation of false memories or distortion of real memories caused by interview techniques that are so unduly suggestive and coercive as to infect the memory of the child, renders the testimony inadmissible under the Due Process Clause of the United States Constitution. The eyewitness identification cases constitute well-established precedent for excluding relevant testimony because the method of eliciting it from the witness was so suggestive as to render the testimony constitutionally unreliable. That principle is articulated in State v. Holen and State v. Hubbard. There can be no due process violation, however, absent some state action. In Perry v. New Hampshire, the United States Supreme Court held that due process concerns arise only when law enforcement officers use procedures that are both suggestive and unnecessary. In the words of the Supreme Court, when no improper law enforcement activity is involved, it suffices to test reliability through the rights and opportunities generally designed for that purpose, notably the presence of counsel, vigorous cross-examination, protective rules of evidence, jury instructions, and the requirement that guilt be proved beyond a reasonable doubt. Here, as early as February 2009, Alexis had talked with Ada several times and was communicating Ada's statements to the police. She participated in building rapport between Ada and the police investigator during the Children's Justice Center interview. From January through the end of March 2011, Alexis repeatedly interviewed Ada at the express request of police investigators and reported this information back to the police. In my view, there is ample evidence that Alexis was acting as an agent of the police. Thus, the alleged witness taint, if any, was the product of state action, and the Due Process Clause applies. Whether witness taint renders a witness incompetent to testify under the Due Process Clause is an issue of first impression in Utah. Several states, including Pennsylvania, New Jersey, Delaware, Michigan, Washington, and Wyoming, have found witness taint relevant in a pretrial assessment of the admissibility of the proffered testimony of a child witness. Kentucky, Ohio, and Alaska have rejected this idea, and New York has divergent trial court opinions. The court finds the reasoning of the Pennsylvania Supreme Court in Commonwealth v. Delbridge, the Wyoming Supreme Court in English v. Wyoming, and the New Jersey Supreme Court in State v. Michaels particularly persuasive. As the Michaels court found, there is a sufficient consensus within the academic profession and the law enforcement communities confirmed in varying degrees by courts to warrant the conclusion that the use of coercive or highly suggestive interrogation techniques can create a significant risk that the interrogation itself will distort the child's recollection of events, thereby undermining the reliability of the statements and the subsequent testimony concerning such events. This court holds that the party alleging witness taint is entitled to a competency hearing where there is some evidence that improper interview techniques, suggestive questioning, vilification of the accused, and interviewer bias may have influenced a child witness to such a degree that the child's testimony may be irreparably compromised. And in fact, the court held such a hearing yesterday morning. In Utah, the general competency of witnesses is presumed, as indicated both in Utah Rule of Evidence 601 and Utah Code annotated sections 78B-1-127 and 128. Therefore, the party seeking to exclude a witness as not competent has the burden of challenging specific testimonial deficiencies such as the witness's ability to perceive, remember, narrate, and testify truthfully. Whether a witness is competent is a Rule 104A determination for the trial court. Usually such determinations are subject to a preponderance of the evidence standard. However, because competency is a presumption under Utah law, the party seeking to exclude evidence bears the burden of proving witness taint by clear and convincing evidence. The clear and convincing evidence standard recognizes that some suggestibility may occur in gathering testimony from children, and that taint may be sufficiently attenuated to permit a finding of competency. The standard recognizes that in most instances the due process rights of the accused are sufficiently protected through the processes and rights associated with jury trial, namely the right to counsel, cross-examination, confrontation, the presumption of innocence, and the right to be proven guilty beyond a reasonable doubt. Finally, competency concerns itself with the minimal capacity of the witness to remember events she perceived. A competency hearing is not concerned with credibility, meaning whether a witness should be believed. Credibility is a jury question. An allegation of witness taint raises a red flag of witness competency, not credibility. The party challenging competency must prove not only that improper suggestive or coercive interview techniques were used, but also that the resulting testimony is in fact unreliable. Reliability of the testimony is the linchpin of due process analysis. Defendant must prove clearly and convincingly a substantial likelihood that the interview techniques used implanted false memories or distorted real memories. Turning to the instant case, for reasons that are inexplicable, trained police detectives in this case permitted a child witness to be interviewed about material facts by Alexis Summers. The record demonstrates that Alexis interviewed the child on multiple occasions. At the time of these interviews, Alexis was Ada's guardian and an outspoken proponent of the claim that defendant had murdered Michele MacNeill. As Alexis testified yesterday, she has been substantially invested in the investigation of this case and has been fighting for justice since the day of Michele MacNeill's death. At the time of the questioning, Alexis was Ada's guardian. Ada had lost her mother, as well as her father in the custody dispute. And Alexis was the last person that Ada could turn to for care. During the period of questioning, Alexis, as stated, was involved in a bitter custody dispute with the defendant over Ada and the other minor children. In addition, Alexis's legal claim to the MacNeill family home turned on procuring more evidence that the defendant killed Michele MacNeill. This strong bias of an authority figure was not lost upon Ada. When asked at the preliminary hearing whether she knew why Alexis was upset with the defendant, Ada responded, "For killing my mom." When asked yesterday how Ada came to know about Alexis's belief in the defendant's guilt, Alexis had no satisfactory explanation, especially in light of the fact that Alexis testified she shielded Ada from all television and newspaper coverage of the investigation. The court is not persuaded that Alexis engaged in open-ended general questioning as she claims. Each time Alexis spoke to Ada, Ada came forward with greater and greater detail, which could only have been the result of focused investigative questioning. The suggestive interviewing of Ada was not all Alexis's fault. In September 2008, Alexis expressed to police investigators professional help. Investigators arranged for the Children's Justice Center interview, but later consistently enlisted Alexis to repeatedly interview the child about material facts to the investigation. Having considered the evidence presented, there is clear and convincing evidence that some of Ada's memories were implanted or distorted by Alexis's repeated interviews with her. In February 2009, Alexis explained that she had talked to Ada several times and kept getting the same story, specifically that 1, defendant had brought her home from school; 2, she ran to the house and called for mom; 3, she went to the bedroom and discovered her mother in the bathtub; 4, she went to the hallway and told the defendant to come quick; 5th, defendant went to the bathroom and told Ada to go next door to get help, which she did. This consistent, simple explanation is largely consistent with Ada's statements to Sergeant Johnston during the Children's Justice Center interview in March of 2009. After that, Ada's memory begins to exhibit remarkable detail, notwithstanding the passage of years. Ada first reported that Michele's head was not at the faucet, but at the other end of the tub. As to this statement, the court is not persuaded that Alexis misspoke when she reported Ada's statement that Michele's head was at the other end of the tub opposite the faucet. In the January 5, 2011 interview with Detectives Robinson and Whitney, Alexis reports Ada's statement more than once and sticks to it even when challenged by the investigator. Knowing that Ada's statement about Michele's positioning in the tub did not conform to the memory of other adult witnesses about Michele's position, Alexis interviewed Ada on this point and helped her draw a diagram. Ada then changed her statement, conforming it to the testimony of other witnesses and stating that Michele's head was at the faucet. In the Children's Justice Center interview, Ada states that Michele was wearing a blue jacket and blue pants. Almost 2 years later, Ada has told Alexis that it was Michele's jogging outfit, a statement remarkably similar to Alexis's statement to investigators in 2008 that she thinks Ada is referring to Michele's running suit. With each successive interview by Alexis at the direction of police investigators, Ada offers greater and greater detail, her memory apparently getting better over time. In January 2011, Alexis reports to Detective Robinson, I talked at length about what Ada saw that morning. I talked to Ada at length about what she saw that morning. She said that Michele MacNeill's head was at the faucet end of the tub. Her hair was going into the drain. Eyes were open and she was staring at the faucet, and she was wearing her jogging outfit. February 1st, 2011. Alexis again had interviewed Ada and provided more detail. The tub was a quarter full. Ada believed that Michele MacNeill was dead. Ada pulled on the defendant's hand to encourage him to come faster. Defendant walked slowly and deliberately into the bathroom. The faucet was not on. February 4th, 2011, Alexis reports to, again in response to a police request, reports to Detective Robinson, quote, I will talk to Ada about it and get you the details. Nowhere is this more evident than Exhibit U, the email from Alexis to Detective Robinson. Their significant new details are alleged to have been provided by Ada, which could only be the source of focused and intense questioning. Alexis reports, she stated that my mom promised to pick her up from school and take her to McDonald's for lunch. She was surprised when my dad picked her up. He was a little late, probably 5 minutes. Only a few people were left at the school waiting for rides. She asked where my mom was, and he said that she was busy and couldn't pick her up. She asked my dad if they could go to McDonald's, and he said no. They drove and parked in the front of the house. Ada first went into the room and noticed that my mom was not in her bed. She said that she remembered all of her medicine next to her bed on an ironing board. She couldn't see my mom in the tub from the door, so she went up on the bathtub step. Michele was wearing her dark sweatpants with the dark bluish jacket with the white stripe. She said that the top was zipped up all the way. She said that my mother was submerged halfway in the water. She saw that her chest moved in and out once or twice. Her hair was floating in the water. Ada said, Dad, Dad, it's an emergency. You have to come now. She grabbed his arm and pulled with all her weight and tried to drag him toward the bathroom. She said that she was walking very slowly. She said, come on, but he still walked very, very slowly to the bathroom. This remarkable level of new detail stands in stark contrast to Ada's testimony at the preliminary hearing. At the time of the preliminary hearing, Ada was 11 years of age. At that age, she would arguably be more able to engage in the free recall required of a witness during direct examination, as well as the recognition memory elicited on cross. However, at the preliminary hearing, when pressed for the kind of detail that Alexis was able to obtain, Ada responded to both counsel, I don't remember or I don't know, more than 40 times. This undercuts the state's contention that Ada's memory and ability to articulate were not the product of suggestion, but simply improving with age. Not all of Ada's memory has been rendered constitutionally unreliable, however. Her original statements, as reported by Alexis in February 2009, and her Children's Justice Center interview are largely consistent. These first statements were taken closest in time to April 11, 2007, and were elicited before Alexis had become an active agent of the police, and in the case of the Children's Justice Center interview, the statement was elicited by a trained professional. More important, these statements are corroborated by other evidence in the case. The presence of Alexis at the home after having been picked up by her father, her finding Michele first in the bathtub, her observations about water being in the tub, and her mother wearing some type of clothing, her summoning defendant for help, and her being sent for help, are all facts corroborated by the statements of other witnesses, including the defendant's own statements. Finally, even if Utah chose to adopt the view of other sister states and find that the Due Process Clause either does not apply due to a lack of state action or was not implicated by the facts of this case, the admission of Ada's testimony would violate Rule 403. In Fulton, the Supreme Court set forth factors that the court could evaluate in balancing the admissibility of testimony under Rule 403. Clearly, Ada has the ability to understand questions and can communicate to the jury. She also has the capacity to distinguish truth from fantasy and falsehood. However, her age at the time of the events was very young. She was 6 years old. There has been a significant lapse of time between then and now. She, as indicated in her preliminary hearing testimony, the degree of her recollection is not stellar. And the most weighty factors of all is that Ada, the evidentiary record before the court demonstrates that Ada is highly susceptible to suggestion by Alexis. And she has been intentionally prepared or unconsciously influenced by adults in her life who are biased and who is her sole care provider. The probative value of a child's testimony procured by repeated suggestive interview techniques of a biased interviewer is low, and that probative value is substantially outweighed by the danger of unfair prejudice. For these reasons, the court grants in part and denies in part defendant's motion to exclude the testimony of the child witness. The court finds by clear and convincing evidence that after the Children's Justice Center interview, Ada was subjected to suggestive and repeated questioning about material facts by an untrained interviewer with bias as to the suspect's guilt or innocence and bias as to her own pecuniary interest. And two, the court finds by clear and convincing evidence that there is a substantial likelihood that these interview techniques implanted false memories or distorted real memories in Ada. Under the Due Process Clause, Ada is not competent to give this testimony. Ada's Children's Justice Center interview was not tainted in this way. Her memories as expressed in that interview are largely consistent with prior statements to Alexis and are corroborated by the statements of other witnesses, including the defendant. In the Children's Justice Center interview, Alexis demonstrated her ability to distinguish between truth and falsehood. She stated that she had perceived events, she remembered them, and was able to narrate her experience.
Your Honor, may I ask the court to put the name Ada? The court referred to her as Alexis.
Yeah, thank you. In that statement, Ada demonstrated her ability to distinguish between truth and falsehood. She stated that she had perceived events, she remembered them, and was able to narrate her experience when presented with proper questioning. Insofar as her Children's Justice Center interview is concerned, Ada is a competent witness. Admission of the Children's Justice Center interview does not violate the Due Process Clause or Rule 403 of the Utah Rules of Evidence. In its case in chief, the state will be permitted to show the Children's Justice Center interview. Ada will then appear in court for cross-examination as required by the Confrontation Clause. On redirect, the state may enter any doors opened by defense counsel on cross. Are there any questions regarding the court's ruling?
None from the defense.
No, Your Honor.
Thank you. We'll be in recess to summon the jury.